My ladies, my lord, I appear alongside Mr. Wand for the appellant, Mr. Carter, and Mr. Stagg, King's Counsel, along with Mr. Messling, appear for the Respondent Police Service.
Yes.
Mr. Wand and Mr. Stagg appeared in the County Court and in the High Court, unlike me. This
your first appearance.
It is, my lady. This is, as you know, an appeal from a second appeal and turns on the interpretation and use of Section 54, subsection 4A of PACE in the context of the facts of this case. My ladies, my lord, we appear here with permission from Lady Justice Nicola Davies on all four of our grounds. And those grounds, if you need them, are at tab 2, page 15 of the core bundle. It may be you're working electronically, and which means tabs of no use to you. So if that's right, I'll just stick to page numbers.
Yes, please.
Her grant is at page 44 of the core bundle, and I suspect you've seen that, so I don't ask you to turn it up.
Yes, I hope it's of assurance to everybody and helpful in terms of how we progress this morning, to indicate that we have had the opportunity and taken the opportunity to read in really quite carefully. So the judgments below are very, very, at first instance, very long. We've read them. Obviously, we've read the judgment of Mr. Justice Spencer. We've viewed the video sections. Actually, I've viewed them in full. We've certainly viewed, at the very least, the excerpts that you've asked us to look at in private. And obviously, we've read the very helpful written submissions on all sides. We've received your supplemental submission. Thank you for that. There's no objection to it, I understand.
There is not.
And so we can just admit that without further ado. So I hope that's a helpful indication.
Thank you, that's very helpful, my lady. In terms of the supplemental, the reason for it is set out, and the respondent accepts that it's the first time, of course, that they've relied on the extraneous material that they have.
Yes.
We don't, of course, object to some of that material, including sort of academic comment, which is a matter of weight. But in terms of Hansard and those debates, we do object. The respondent's primary position is that the meaning of Section 54(4)A is not ambiguous, but if the court thinks it is, then the respondent wishes to rely on that, some of those parliamentary debates. We argue that the manner in which Section 54(4)A power read together with Section 54(3), 6 and 6A to 6C, and of course I'll come to all of this in due course, the manner in which it's being exercised on these facts and more generally calls for the importation of a reasonableness requirement. And that is because of the wording of Annex A to Code C, and further because we say that is a Human Rights Act compatible reading. Therefore, we say, even if there is any obscurity, the weight to be attached to the pre-enactment material, all of which predates, of course, the Human Rights Act, is necessarily reduced for the purposes of construction.
So, as I understand it, look at the pre-enactment material, but proceed with great caution if you... Yes? Is that a sort of basic summary?
Yes, that's a basic summary, but we also, in our skeleton, set out this, even if you did receive it, the Bene essay, you'll see, for example, that there are no, the sort of pepper and heart test is not satisfied in the sense, or there is no clear statement of principle.
Right.
Being...
But I thought you were accepting that it was, I've written down it's admissible, but it's all a question of weight. Have I misunderstood you?
Yes, sorry, there were two arguments, which I'm sorry if I didn't make that clear.
No, it's my fault. My fault.
The Royal Commission report, the academic extracts and that kind of material we have said in our skeleton it is admissible, but it's a matter of weight. We've said that in our skeleton that the Hansard debates fall foul of the Pepper and Hart test.
Okay.
And that is really the last two limbs. But ultimately, it's a matter for you once you've heard full arguments.
Of course. And before letting you expand, and I promise you that I'm not going to interrupt again, but just to understand your headline position, you keep emphasising, and I understand why, it's all about these facts.
Yes.
Are you saying that a requirement of reasonableness sometimes, depending on the facts, does not exist in section 54(4)(a)?
No, my lady, I say if section 54(4)(a) is permissive of forcible strip searching, then in those circumstances the test must be objective. And that is the way it is being read up and down the line.
But if the clothes or personal items or effects, whatever the word is, being removed is, say, just a belt or a tie, just a tie, so minimal to no invasion of dignity, no Article 8, then no objective test. Is that what you say?
Yes, my lady.
Right, thank you. I'll be quiet now, I promise.
I know it's undesirable to have more than one test, but that is the way in which we say matters have progressed and the way in which Annex A expresses itself. Broadly, we rely on the principle of legality, which will be well known to you, and supplemented by a convention-compatible construction rule. And we've set out the passages in Bennion, and they're in the authorities bundle. So Bennion, chapter 27, at page 376 onwards, and chapter 29 of Bennion, which is at page 380. I don't want to insult the court by setting out what those principles are, because they'll be so well known to you. We say, of course, that the court should be slow to impute on the legislature an intention to override established rights and principles or commission of torts where it's not clearly spelt out. And we say here that section 54 does not clearly spell out that you can strip an arrestee naked for the purpose of seizing their clothes, which a police officer believes can be used to cause injury. And my lady, the respondents rely on extracts from Professor Michael Zander's book on PACE, and those extracts you will find at page 399 onwards, but I don't at this moment ask you to turn it up, just to give you a summary of what he says, and that's at 5-06. He says that this is factual, which is why I refer to it. There are various PACE sections that deal with searches of the person.
Sorry, 50.
Sorry, my lady.
In Zander, 50.
506, page 399 of the authorities bundle.
Right, thank you.
506. There are various PACE sections that deal with searches of the person. None of them say anything about strip searches. He says, nor is there a definition of strip search in the Act. The only definition of the PACE systems is in Annex A. Paragraph 9 of the PACE Code C, which states merely a strip search is a search involving the removal of more than outer clothing. And then he says, he quotes, and in this code, outer clothing includes socks and shoes.
But was this really a strip search? It was a removal of clothes for safety reasons.
My lady, you will see that in the case of PD, which we rely upon, that is the way in which Lord Justice Pitchford finds that it is a strip search for the purposes of Annex A.
Well, I may be wrong, but in PD it was a section 54(6) search.
No, my lady, it was the same provisions being utilised.
Okay.
I'll take you there,
Yes.
if I may, in due course. So Professor Zander expresses various other opinions, including the need for regularisation of the position by legislation, given it's his view that Section 54 is unclear as to when a strip search can be conducted or when it should be authorised, and you'll find that if you want it at page 398, and I may come back to it. My ladies and my lord, we say it's uncontroversial that stripping someone naked in the way that Mr. Carter was and destroying their clothing as his was engages both Article 8 and 3 of the European Convention of Human Rights and interpretation appropriate before the HRA came into force may have to be reconsidered and revised in light of the Section 3 interpretive obligation. As is non-controversial in the Article 8 context, when interfering with Article 8 rights, we say domestic law, well, it's a principle, domestic law must indicate with reasonable clarity the scope and manner of exercise of the relevant discretion conferred on the relevant public authority, so as to ensure to individuals the minimum degree of protection to which they're entitled under the rule of law in a democratic society. In addition, given the prohibition on inhuman and degrading treatment enshrined in Article 3, the forceful removing of clothing for someone's own safety or indeed for the safety of the police officer to be compatible with Article 3, we say the reason for the strip search or the stripping needs to be properly justified. And we say, my lady, that honest belief is insufficient. Relatedly, to demonstrate the concerns in different corners of the country around the use and misuse of Section 54 in the context of the removal of detainees' clothing and the use of force to do it, we have included some extracts from the HMIC reports from different police forces. I can take you to them or simply give you the references, whichever.
And so what are we getting from this material?
You will see that the inspectorates highlight concerns about the insufficient justification, including stripping solely due to answer risk assessment questions. So the insufficient justification for the forceful removal of clothes and the lack of governance of the use of force in police custody streets. So those are raised as matters of concern by three different inspectorates.
And it is going, what, to the point of construction or to the grounds 2, 3 and 4?
Sorry.
Is this going to the point of construction on ground 1 or going to grounds 2, 3 or 4?
It goes to ground 1.
Can I just ask a little bit more about that, Mrs. Binder? How does it help us on construction? I mean, it may be that all we need to do is look at the words and decide what it means, what the particular piece of legislation means, and how does the way in which practice has developed or not developed countrywide help us on that issue?
Well, those concerns raised by the various inspectorates going into custody suites up and down the country about the way in which Section 54 is, we say, being misused, and therefore we say...
Well, if that arises from the words of the legislation, then it might mean that the words need amendment on due consideration, but it can't affect, can it, the interpretation that we give to the words themselves?
No, my lady, it can't affect the... but my lady, the Lady Chief Justice asked me, am I talking about the way in which clothing was removed in this case? I simply say that that is the way in which Section 54 is being interpreted, not just in this case, but up and down the land, and therefore there's a greater imperative, I suppose, to deal with this matter in the way in which we suggest. But I hear you. You say
But you give us the reference.
Principal
and that's how you put it. The references are
pages 347 to 352.
right. Thank you.
On the CCTV footage, thank you for the indication that you have, of course, that you have viewed it in private. We make this one point about the CCTV. The passages that you're asked to view are the passages that the respondent asked you to view. We didn't say anything about it, but we question the relevance of the respondent asking you to view Mr. Carter's behaviour after he has been stripped naked, how he behaved post the debasing strip cannot assist you in any way to judge the police actions prior to that event. And those are ground 2 and 3 points as opposed to ground 1 points. Before I turn then to the detail of ground 1, my lady has indicated that you have read the liability and content judgments of Recorder Dagnall, and of course the liability judgment is 240 paragraphs long. It is meticulously detailed.
It was all oral, was it? It was read out all orally. Yes.
Yes, it was.
Yes.
Yes. We say it's balanced and reasoned throughout. We say it refers to all the relevant case law that was put before the court, as well as the full statutory context, as well as relevant parts of PACE, Code C and the College of Policing Guidelines.
And there's no challenge to the findings to dismiss the claim on phases 1 and 3?
No, there wasn't in the court below, and obviously there can't be now.
No.
There are some findings which are unchallenged and are relevant to the context of our arguments today, which I want to draw to your attention, please.
Of course. Yes.
So first, before the appellant was brought before the custody sergeant, he was refused access to a toilet, and that was found to be unjustified. And the recorder says at paragraph 125, which you will find at page 156 of the core bundle.
I do struggle to find out. So how is this relevant?
Because it indicates that the way in which, and it's important to ground 2 in particular, that the way in which Mr. Justice Spencer viewed events was not in line with what the recorder did. And so he focused on what happened to the appellant before he came in front of the custody sergeant in order to look at the full context of what then transpired. And it's important also because he found that what happened there was deeply humiliating and degrading, and that it was likely to damage his behaviour in one way or another during his further incarceration in the police station, and harm his ability to deal with the experiences a person might ordinarily be hoped they would deal with it.
I think in paragraph 124, the recorder says that no claim is made in relation to any
Yes,
of that.
that's right.
So why was the recorder saying all this about it?
Because in order to interpret what happened at the custody desk, he was looking at what went before.
Did he explain what the importance of it was, anyway?
Well, he explained, therefore, that the man who appeared in front of the custody sergeant and was asked a series of questions was not answering them in the context of what had just happened to him, including being forced effectively to urinate himself. And that context is extremely important, we say. He also said in that judgment that during the course of what was going on in front of the custody sergeant, that all the claimant was trying to do was stand up and get some space rather than seeking to assault the police officers. And that you will see at paragraph 146. And you may have reached that conclusion yourselves, having viewed the CCTV. The recorder also found the claimant's evidence to be credible, and he found that simple non-cooperation, well, he said it seems to him that simple non-cooperation was a dubious justification for throwing him to the ground and securing him. And as far as the bite to PC Young is concerned, and the respondent relies on that, it was said, just so we're clear about the factual matrix, that it was through a latex glove and there was an impression and possibly a small cut to the skin, and you will find that at paragraph 134. We say also important is that the recorder found that no actionable wrong had been committed by Mr. Carter, and you will find that at paragraph 155, page 161, and he found that the claimant honestly and reasonably believed that police officers were unjustifiably throwing him to the ground when he was simply seeking to stand up. So he describes those actions as reasonable self-defense. And lastly for now, and importantly, in relation to the stripping, at paragraph 164, he found that Mr. Carter was in fear, bewildered, worried he was going to be physically and sexually assaulted. And at paragraph 166, that highly inappropriate comment was made to him by a police officer. So he found that what was occurring would have been terrifying to any reasonable individual, and it was for the claimant to be surrounded, have his face pushed down to the floor, have his clothing forcibly removed, and feathers released, which threatened to suffocate him, and that it was, in the recorder's words, deeply degrading and humiliating. And no Article 3 claim was brought, but we say it is obvious that the Article 3 severity threshold was crossed. As I say, you've seen it for yourself, and you will form your own view. It may be of assistance for you to understand the risk assessment questions that it is said were not answered, and so because they are not set out in full in either judgment. So if I could just take you then to the supplementary bundle at page 137. and that is the back of the custody record. You can see that the questions are broken into two. One are questions and answers for the officer's own assessment. So that is what the custody sergeant has to do for herself. Questions such as, does the detainee appear injured or unwell? And the question that she must answer herself is, does the detainee have any indications of self-harm? So that's the first stage of her risk assessment. The questions and answers for what is described as self-assessment are further down, and those are the questions that it is said that the appellant did not answer. There's no dispute that he didn't answer the questions being asked of him. I can't say exactly what was asked of him.
So we get the yes to mental health issues, depression, receiving treatment, awaiting counselling and medication from the GP. Do we know where that came from, if I missed something?
Yes, that was much later on. If you see the entry...
2339.
Yes,
Yes, I see that.
That was by a different custody sergeant who came on duty later that evening and
Yes, I
who
see.
then
Yes.
asked those questions.
Yep, thank you.
But you can see, my lady, have you ever tried to harm yourself? The answer is no. And there was no concern at that stage by that custody sergeant about a risk of self-harm.
I see one of the answers to the questions he was asked, must have been the appellant was asked for self-assessment, was whether he'd taken alcohol within the last 24 hours. And he said no.
Yes. That's the difficulty with self-assessment questions. So we say the idea that one can rely entirely upon a series of questions asked about a detainee as a reason for not being able to risk assess them can't be right. It's obvious that there is an objective assessment that the custody sergeant must make, and the questions that are detailed.
They've got to judge the person who appears in front of them.
Correct. And yes, but there is, in this case, it is said, and it was said by Mr. Justice Spencer, that it was open to custody sergeant to simply strip somebody of their clothing on the basis of refusal of these questions. And you can see that that can't be right, because a detainee can tell you whatever a detainee wishes to tell you. And can I take you then also to look at the College of Policing APP guidance on this, which you will find in the authorities bundle at page 338, please. This is the guidance on detention and custody and risk assessments generally. And if you look then at responsibility for risk management, you will see that there is a responsibility not just on the custody sergeant, but also on the arresting or escorting officer. It says the arresting or escorting officer should make checks with any immediate available sources of information relevant to the welfare of the arrested person, and this may include the detainee. If you go down, you will see the checklist as suggested, these are the questions that the College of Policing suggests that should be asked. They're not exactly the same as the questions asked by Essex Police, but they are reflected. You will see that the College of Policing on the self-harm question adds a further question which is not in the Essex Police custody record, which: have you ever tried to harm yourself? If yes, how often? How long ago? How did you harm yourself? Have you sought help? But if we look further down that page, under Police National Computer, it says the PNC should be considered the primary reference for recording and accessing risk information. Custody staff should have direct access to the PNC at all times. And that is the point my Lady Sharp just made, that the custody sergeant must satisfy herself. And therefore, what a detainee may or may not answer may shed further light to that assessment, but it certainly could not be determinative. So, to summarise, on ground one, the legal arguments that I'm about, I hope to make good. The test does have an objective element. The proper reading of section 54.4a looked at in the context of the other subsections, section 54, as I said before, along with Code C, paragraph 4 and Annex A, drives you to the conclusion that an objective test is to be inferred. Under PACE, police officers are required to act in conformity with Annex A of Code C by reason of section 39. And of course, I'll come to that. And Code C has a special function, unlike other codes of practices in other statutes. And that is because of section 67, subsection 11, which I will also take you to. We say, in addition, a common law and in particular Human Rights Act compatible reading requires that objective test to be read in. We note that in both the PD case and Yusuf, although neither case turned on this, the section 54.4a test was considered to import reasonableness. And I can take you there. So authorities bundle page 105, please. And if you, and as I say, the case did not turn on this, but I refer you to it in any event. So at paragraph 5, Lord Justice Pitchford made the point that there is no appeal against the recorder's finding that the custody officer, Police Sergeant Gilmore, acted reasonably and proportionately in deciding that there was an urgent need for the removal of the claimant's clothing. And at paragraph 5, my lady.
Of PD.
Of PD. Mm-hmm. Yes. At paragraph 44, and I'll come back to PD for a different purpose, but at paragraph sorry, I'm just trying, I've got the wrong...
We had a brief discussion about PD, the facts. Paragraph 21 and onwards,
yes.
Is it not right that this was a section 54.6 search?
Well,
Subject to subsection below, a person may be searched if the custody officer considers it necessary to enable him to carry out his duty under subsection 1.
Well, there was no difference. If you look at the decision, is really, if you look at paragraph 33, where you will see.
So we're talking about the power to seize, section 54(4,
Yes.
and then subsection 6 is the compulsory process
Yes, but when
for
I take
finding
it to
clothing and articles and or seizing them as a search.
Yes, so there is in a sense, and I'll come to that, 6 and 6A, the difference between them, and 6A, as you know, came into force later, but 6A gives the police the power to remove clothing at any time, whereas, I'll show you this, whereas 6 refers back to section 54(1). So it was never argued here that this was only section 54(6) power being used, because if you read on, what Lord Justice Pitchford says is that it is the, if you look at 6 and 6A, that's where you get the power to search. And then if you read backwards, the section as a whole contemplates the seizure of clothing pursuant to the power under subsections 3 and 4, and the end results of the search conducted on the power given by section 6 or 6A, whether the officer is looking for property other than clothing or is seizing clothing itself, and happily he considered that I was right in the way in which that section operates. It may make more sense, my lady, once I take you to section 54(6) and 6A, but there's no suggestion here that there was that the strip search, so-called, was conducted merely under section 54(6). We looked at the whole of section 54, and you will see that the power to remove and seize clothing arises in slightly different circumstances, which are not altogether clear in section 54. So, the other point that Lord Justice Pitchford makes it at 44, and again it's obiter because the challenge to the exercise of discretion was not brought in the court below. He says, I'm bound to express concern that it should have been thought appropriate immediately to remove the clothes of a distressed and vulnerable 14-year-old girl without thoughts for alternative and less evasive measures to protect her from herself. And he goes, but in the absence of challenge to the judgment on wider grounds, it does not seem to me that the appeal can succeed. Again, and I will, my lady, come back to PD. If you look at the case of Yusuf at page 133, you will see there that the Court of Appeal again proceeded on the basis that it was a reasonable belief that was necessitated, although that wasn't the basis of the challenge. You will see at 66, in the circumstances the judge found on fully sufficient evidence that a strip search, inevitably humiliating, was an entirely appropriate response to the circumstances on the ground that it was necessary, brackets, or reasonably believed to be necessary in the interests of Mr. Yusuf's safety. We add to our argument that an automatic assumption of self-harm from a failure of a detainee to answer a custody sergeant's risk assessments question cannot amount to either reasonable or indeed honest belief.
Can I ask you two questions arising out of that? First is the use of the word honest belief, because
Sorry, my lady.
I want to ask you two questions arising out of that. First, the question of honest belief.
Yes.
Is it not sufficient to say belief? You either have a belief or you don't, surely.
Is it not sufficient to say
Belief.
Actual belief as
Actual
opposed
belief.
to honest belief.
Oh, I see. Well, actual belief has always been interpreted as honest belief.
It's not helpful, is it, to talk about honest belief if what we really mean is actual belief?
Well, they're the same thing, are they not? Certainly, that was the approach I think my lady took in Affray, which I can come to, that looking at reasonableness, it was a two-stage test, and one was the honest belief, and then the objective part of the reasonableness test was the objective test, but it's always been approached as belief is a subjective belief, and that belief must be honest, because you obviously couldn't have a dishonest belief for it.
Well, if the belief was dishonest, it wouldn't be a belief, would it? I'm just wondering what the word honest adds.
Well, I suppose it protects against malafidis. So you could have a belief,
But then it wouldn't be a belief. Wouldn't be an actual belief, because you wouldn't believe it.
Yes, but in the context of the exercise of police powers, it certainly, we would say, would need to be honest.
Can we just see, can you put me out of my misery? What did we say in Affray on this?
In Affray, which you will find starting at page 200.
Mm-hmm.
You say, is the whole case turned on Mrs. Justice Hill's finding that PC Pringle held an honest belief.
Yes, so that was the judge's finding below, and there's no challenge to that, yes?
Yes, and you, my lady, found that that the objective test includes requirements of reasonableness and notions of proportionality and necessity, and you found that at paragraph 47.
Go on.
But that's the objective part of the test, which I was going to come to. But
Well,
yes,
that's actually not what I found at 47, doesn't matter, but there we are. It was all about plan.
yes, but you say plan doesn't add materially to the requirement of reasonableness.
But that's reasonableness to the use of force, not to the belief.
Yes.
So it has nothing to do with reasonable belief.
No, but it's just about the way in which reasonableness is assessed. It's in all police powers, it's a two-stage test, whether you're talking about reasonable grounds to arrest or the notion of reasonableness. It imports two stages to the test. One is honest belief and the other is the objective belief, which is why we say
Just to be clear, this is the requirement of reasonableness for the discharge of the taser.
yes.
Yeah.
But reasonableness in that context, my lady, you did find includes notions of proportionality and necessity. which must be right, and that's what the law to date has always said. If I could turn now, please, to why and where Recorder Dagnall found that the Section 54(4)(a) test was reasonableness in this context, and his summary reasons you will find at paragraph 181 of the core bundle, which is page 166.
Sorry, Victoria, you have two questions and I cut you off. Right, if you want to send there, sure. Okay, thank you. Yes. Paragraph 181.
Paragraph 181, page 166. And at 181, you can see the crux of his findings there, that the custody officer would need a reasonable belief that such a step was necessary to prevent clothing being used to cause physical injury, and the police must act proportionately and reasonably. Secondly, that reasonably and proportionately must be seen in the context and the light of paragraph 11D of Annex A, and I'll come to that. And in that any event of this nature must be carried out with proper regard to the sensitivity and vulnerability of the claimant, and every reasonable effort must be made to secure the claimant's cooperation and prevent embarrassment, and that is not normally required to remove, and it's not normally required to remove all of a person's clothes at the same time, and that's a reference to what it says in Annex A. He then goes on to say that all of this is to be seen in the light of College of Policing guidelines, that a detainee must be treated with respect, that there should be de-escalation, and also that the negative impacts of restraints, yes, so he talks there about balancing the risk and the need to treat the detainee with dignity. And he also refers to the College of Policing guidelines, which say that the removal of clothing itself can increase the risk of self-harm. And those guidelines also say that observation may be the more appropriate course. So you can see that he relied not just on Section 54, but Annex A and the College of Policing guidelines. And if we then look at Mr. Justice Spencer's reasons for disagreeing with Recorder Dagnall, those can be found at paragraph 47, which is at page 65. Obviously, this is where he comes to a conclusion, and this is the passage which we now impugn, in the sense that it's the core of his reasoning. He says, in my judgment, despite the provisions of...
So we've read that paragraph carefully.
Oh, all right.
Thank you. I mean, you say that there was analysis in the first instance judgment. There are no reasons given for the finding that a reasonable belief would be needed in paragraph 181, are there? There's no reasoning. There's no statutory interpretation.
Oh, sorry, from the recorder?
Yes.
Well, yes, because he says he reads in Annex A, and there's a reasonableness requirement within it.
No, well, he doesn't, because he says first, you need a reasonable belief. Secondly, reasonably and proportionally must be seen in the context and the light of Annex A. That's not saying Annex A is a reason for there being a need for reasonable belief.
Well, that was the argument that was made in the court below.
So you say that that's really what he was trying to say?
That is what,
Okay.
If you look at his judgment in a wider context, it is what he is responding to, because that's certainly what Mr. Wand put to him.
Okay.
So we've seen what Mr Justice Martin Spencer says. So to understand what the recorder is saying on this question, he's saying, you say a wider reading of the judgment involves some reasoning to support his conclusion that the police, in his words, would need a reasonable belief. Do we find anything to support that?
Sorry, do we find anything to support
Any
what?
reasoning to support his conclusion that the belief that the police have must be a reasonable one?
Well, that passage that I took you to is just the culmination of where he lands, as it were. He sets out the arguments that are being made to him, which include the argument that was made by the claimant in the court below, that if you look at Annex A properly, you will see that there is a reasonableness requirement. And I'll come to it and point you to it so it makes more sense. We say that Mr. Justice Spencer doesn't really grapple with Annex A at all.
But what is there, just to interrupt, I'm sorry, but if we're really doing this exercise, 11D of Annex A, which we find at 313 of the authorities bundle,
Yes.
there's nothing in D
No, but there is.
that could possibly affect this question.
No, but there is, if you look at paragraph 10, which is what was put to recorder by Mr. Wand, and I'll find you those passages in a moment.
I mean, ground one is pretty short. It's all, you say Annex A and Articles 3 and 8, and you say that paragraph 10 of Annex A refers to reasonably considers.
Yes.
PD, Lord Justice Pitchford said that paragraph 10 doesn't apply to this sort of situation.
Well, he doesn't quite say that.
But does it? It can't apply. It's not. The search was not taken place. Well, this wasn't a search for the purpose of removing an article. And you can't argue that paragraph 10 limits the scope of permissible strip searches. So what Lord Justice Pitchford said in PD was paragraph 10 didn't apply to the PD situation. And
yes,
it doesn't apply here either, does it?
Well, we say it does, because what Lord Justice Pitchford said there is that sorry, I'm just trying to find my note, forgive me, that the search, although not an exact descriptor, includes removal of clothing. He says that at 34. And he says paragraph 4.1 of Code C applies because that's when more than outer clothing should be removed. And Annex A applies, and that Annex A applies to forcible removal. All he says is that
Paragraph 10 fails to provide for those situations anticipated by Section 54 in which the custody officer wishes to seize any clothing that may be used by the detainee to harm herself. So he's saying there, paragraph 10 doesn't apply to the situation where you're seizing because of the risk of harm.
He doesn't say it doesn't apply. He simply says that it is that it fails to provide, and he goes on to say this is a lacuna in the code. But he then goes on to say that paragraph 11 of Annex A applies to any strip search.
Yeah, all right, but just to deal with the key word for you, that, as I understand your construction argument, is the word reasonably in paragraph 10.
Yes.
So your submission is that Lord Justice Pitchford is not saying that paragraph 10 only applies if you're doing an article search. He's saying it just fails to provide for the situations where you're just seizing because of the risk of self-harm. That's your submission.
And there's no reason, we say, to distinguish between the scenario in
Okay.
at paragraph 10
Okay.
from the scenario that we find ourselves in this case. Can I then turn to the original justification of the custody sergeant as she recorded in the custody record, and you'll find that, please, in the supplementary bundle. You've just been to the custody record, but it's at page 119. Sorry, it's a bit smudged there, but it's also set out in the High Court judgment.
Thank you.
And in the High Court judgment, you'll find it at page 54. Only the uppercase is her entry, and that was established on the evidence. The rest of that entry is a pro forma entry, as she explained in her evidence. So her reasons are the DP is violent and had to be taken to the cell. A strip search is only being authorised for the purpose of changing him into anti-self-harm clothing, as he cannot be risk assessed. This will involve the exposure of intimate parts of his body. My lady, you will see that the written entry does not indicate her state of mind at all as to what her belief was, or otherwise, simply that he cannot be risk assessed. Can I now please turn to section 39 of PACE, which is at page 29 of the authorities bundle. And 39 1A sets out that the duty of the custody officer at the police station is to ensure that all persons in police detention are treated in accordance with this act, and that, yes, that are treated in accordance with this act and any code of practice issued under it, and relating to the treatment of persons in police station. And that all matters relating to such persons required by such person to be recorded. And to understand the section 39 provision a bit further, may I please take you to an example of its application in the case of Pyle, which is relied upon by the respondent, and that is at page 196, please. In that case, the High Court found that the removal of vomit-soiled clothing replaced with dry clothing of an inebriated detainee was not a power contained in Section 54, but was one that was available in the relevant PACE Code C of practice, PACE Code of Practice Code C. And if we look at paragraphs 30 to 34, you can see that Mr. Justice Turner found that the police were required to act in accordance with Code C. Otherwise, the Section 39 duty would be breached. And he says that at paragraph 32, and that such an approach was in conformity with the Article 3 systems duty, is what he goes on to say. So this, we say, is a position with Code C, in particular that custody sergeants are required to act in accordance with it. if we could move on then to look at section 54, the original enactment you will find at page 16 of the authorities bundle. You can see that the title of the
4A and
section-
B don't change, do they?
Sorry.
Subsection 4A and B don't change.
No, that doesn't change, but as you'll see in a moment, other parts do, and I'll explain that. But yes, the belief as set out at A and B hasn't changed. And you can see that the purpose of section 54 appears to be searches, although search itself is only referred to at subsections 6, 7 and 8. So seizure and retention of equal import, albeit it's right to say that the seizure of clothing and personal effects under subsection 3 may only be possible following a search as per subsection 6, but looking at it as a whole, it looks as if section 54 is about a duty to ascertain, and the parallel powers of search and seizure upon a detainee's entry into the police station. It's really about ascertaining at this point what they have with them, and the power to make a full inventory of those items, although of course there are those references to search, but as I've already said, there is no definition of strip search, and as originally enacted, there is an ascertaining of everything a person has with them, then a seizing and a retaining of any such thing, so that it is talking about anything that a person has with them when they enter a police station, subject to a carve-out for clothes and personal effects. They may only be seized if 4A or B are satisfied, and of course I acknowledge the difference in language, that for the purposes of seized clothes and personal effects, the custody officer must believe that those items may be used in particular ways as set out, whereas if it is evidence, you need reasonable grounds to seize them, which is consistent with other sections of PACE which interfere with civil liberties pre-charge. Although when you look at the amendments later, arguably there is no power of search for evidence, and certainly that is the view of Professor Zander, but since we're not looking at that section, it's not determinative of the issues we have here, but the difference in language, we say, is not determinative, because the power to seize clothing or personal effects which may cause personal injury to the person does not specifically contemplate stripping someone naked, and there's nothing in this section to suggest that that was in the realm of contemplation of Parliament. And of course, my lady will note that at paragraph 7, it simply states that an intimate search may not be conducted under this section, and it seems that the power of strip search is placed deliberately and entirely in Annex A, and certainly that is what Professor Zander appears to set out. So if we move on to the current version, which is page 32, there's some changes at the beginning to recording and the classes of detainees, but otherwise the same until we get to 6A, and 6A is about searches for the purpose of 54.4A and not B. It is much wider than 6. 6 refers back to the custody sergeant's duty under subsection 1 to ascertain everything the detainee has with him when he comes in. 6A appears to be widening the power to search clothes and personal effects, firstly widening it to at any time, so not just when a detainee first comes in, and for anything, not just anything he has with him. And there appears to be no requirement.
Sorry, it is still with anything, whether he has with him.
Sorry?
It is still limited to whether he has with him. 6A.
Yes, but whether he has with him anything which he could use for any of the purposes specified, whereas 54.1 appears to say ascertain everything which a person has with him when he is brought to the station. So,
I understand the temporal widening, but I don't see any other widening.
sorry, yes, temporally wider. Well,
Because it all relates back to 4A.
sorry, Melanie.
The critical thing is that it all relates to that he could use, which he could use for any of the purposes specified in subsection 4A.
Yes, of course, but the odd thing here, though, is that because there's a temporal extension, there appears to be no duty of the custody sergeant to authorise the stripping, because if you look at subsection 6, that's if the custody officer considers it necessary to enable him to carry out his duty. Whereas 6A, because it widens the time, it would seem, there isn't a duty for it to be authorised by a custody sergeant. And that is a point you'll see that Professor Zander makes. And we say that makes it all the more important for there to be the protection of an objective test. So the rest is as before, apart from 6B adds seizure and retention from anything found in 6A. 6C appears to be
And these amendments were introduced in when?
if you look at footnote 6 on the following page, by the Criminal Justice Act 1988.
Thank you.
So some years later. So clothing is not defined in the Act, so no distinction is made between outer clothing, that is to say socks, shoes, laces, jackets, etc., and underwear. That is all dealt with in Annex A. So there's nothing in this section that refers specifically to the removal of more than outer clothing, which is why we say Annex A of Code C is crucial to understand the limits of the power to seize clothing.
Sorry, just to go back, forgive me for interrupting, but just following on your point,
Yes.
6A, introduced in 1988, so well after the enactment of the legislation, you don't need any, as you say, no custody officer authorisation, and there is no need for any belief. It is, may at any time be searched in order to ascertain whether he has with him anything that he could use.
Yes, well, although of course it requires 4A to be satisfied as
Any of the purposes specified. Now, the purposes specified are causing physical injury to himself, damaging property, etc., etc.
yes, but what is odd, though, of course, is that subsection 4 refers to the custody officer.
Well, it's not odd, is it? If something happens which makes, despite what happens at the desk, somebody goes into a cell, and then it's considered that they need to search the detainee. Why is this odd?
Sorry,
Because
say
if they
this
think
again.
it gives the police the power to search somebody to see whether or not they have anything which may be used for the purposes specified in 4A. Why is it odd that that should be a continuing power? There should be a continuing power to do that.
Simply because it doesn't appear to have the oversight of the custody sergeant. But this is one of the points that Professor Zander makes as to why proper legislation is necessary, because it appears to give any old person the power to strip someone naked.
So Professor Zander is saying that this is all inadequate.
Yes, yes.
Right.
6A. Yeah.
Of course, that is academic view, but we simply say if that is right, then that's even less protection, and that is why we say it's even more important to ensure that it's not...
Just so I put it fairly to you, I'm struggling to see why the belief in 4A is engaged by the reference to the purposes specified in 4A as referred to in 6A.
Well, because you've got to believe that the clothes and personal effects are going to cause physical injury to any other person. You can't just have physical injury without believing that they are going to cause physical injury.
Is it said against you that these sections coming in after the enactment of the original legislation are not permissible aid to construction? Is that a point taken against you?
I don't think they may well be taken out, but
Right, okay.
So what is 6A introduces a new power to search on occasions other than the existing power. And
appears to be the case.
yeah, and it's a power to search in order to ascertain whether he has with him anything which he could use for those purposes. So it doesn't appear to relate to clothes, because you don't need to search somebody in order to ascertain whether they've got clothes on.
Well, that's the language throughout the Act, even in Section 6.
Sorry, what do you mean?
So my Lord's point is that
This looks like a search for articles which you can't perceive without the search, but you can see whether somebody's wearing trousers.
it may well be that is what something that is not readily apparent.
Yeah.
So, although
I mean, by definition, you don't know, because the power is in order to ascertain.
yes, that's what I meant about the widening, because of course it could incorporate matters that somebody has subsequently come into possession of.
Okay.
As opposed to just
I'm sorry, we're
as we
bombarding
can.
you with questions, but just in relation to your point that there's some sort of odd distinction between, as it were, the power and the duty of the custody sergeant and this power which you're addressing us on now, I think it's important also to look at 6C, isn't it, which is in relation to seizure, which is, after all, what we're talking about here. A constable may only seize clothes and personal effects in the circumstances specified in subsection 4.
Yes, I suppose that deals with
It does, doesn't it?
my lady's point about why belief should or shouldn't come into play. 6C
So it's
makes
consistent.
that claim.
It's consistent.
Sorry,
There is a consistent approach.
yes, yes. Yes, I accept that. But it's not just purposes. It's the belief system. If we just turn then to the relevant parts of the code, please. Authorities bundle, page 309. Yes, starting at the bottom of that page, just looking at what it says at 4.1, what the custody officer is responsible for. And that's the point I was making about section 54.1, my lady has with them when they come into the police station. But it goes further to say, or might have acquired for an unlawful or harmful purpose while in custody, so it's not limited, therefore, to 54.1. It then goes on to say, custody officer may search the detainee or authorise their being searched to the extent they consider necessary, provided the search of intimate parts of the body or involving the removal of more than outer clothing is only made as in Annex A. And then there's the same sex point, which is already in the statutory, in the statute. 4.2, detainees may retain clothing and personal effects at their own risk unless the custody officer considers they may use them to cause harm to themselves or others, interfere with evidence, damage property, effect an escape, or they are needed as evidence. There is no distinction between the evidential part and the other reasons for retaining. It simply says the custody officer may withhold such articles as they consider necessary. And then the duty to give reasons is at 4.5. And you'll see in the notes for guidance, which refers to 54.1. It doesn't take us much further other than to say that there is a continuing duty, that you don't have to search everybody when they come in. And then if the detainee refuses, custody officer will be obliged to ascertain what property. So more importantly, at I just want to make this point. There's at 4.2, there's no distinction made between section 54.4a or b. It's just about language of necessity. So if we move then to page 311, please. And you can see that Annex A talks about intimate searches, which the definition of which makes Part A inapposite. But if you go over the page, we move then to Part B, which is entitled Strip Searches. And what my lady said is this really a strip search that is the language of the code. It says a strip search is a search involving the removal of more than outer clothing. In this code, outer clothing includes shoes and socks. Then that's the point I make about paragraph 10, a strip search may take place only if it is considered necessary to remove an article which a detainee would not be allowed to keep, and the officer reasonably considers the detainee might have concealed such an article. Shouldn't be routinely carried out if there's no reason to consider that articles are concealed. And as I've already said, we say there's no reason to distinguish between strip searches carried out for purposes of removing an article or strip search for the purpose of removing an article hidden, or strip searches for the purpose of just forcibly removing or just removing clothing. We say that the protections ought to be exactly the same. And we say that is the essence of the decision in PD. Paragraph 35 of PD, Lord Justice Pitchford does say it is entirely to be expected that Part B of Annex A should apply to all strip searches. My lord, just for completeness, you will see that the protections set out at paragraph 11 are specifically the greater protection when strip searches are carried out, which cannot be gleaned from the statute itself. So precisely we say because it is a strip search, not because of the search part, but because of the strip part.
Well, can I just challenge you on that? Just so, speaking entirely for myself, I see what Lord Justice Pitchford said about paragraph 11, but do you agree that there are parts of paragraph 11 that can only apply to a search for articles as opposed to the removal of and seizure of clothes?
Yes, that we conceded that in PD that was conceded.
Right, so we look at the we look at the second sentence of D. That's, and do we look at the look at F?
We look at well, there's no reason why A and B don't apply.
It's just a question of perhaps to use the word interpretation. I mean, once you start the heading action, 11 following on from 10, if 10, and your position is it's not limited to searches for the removal of articles as opposed to the seizure of clothes. We have that submission.
Yes.
But if that submission is wrong and 10 is not apposite to this sort of situation, then why is 11 also not apposite and to be read in the context of a search under paragraph 10 and not a wider one?
So, sorry, 11 is about the conducting of all strip searches. That is obvious, and that is what PD
And why is it obvious?
Well, because a strip search is defined as at 9. Mm-hmm. And if you
and
follow
what do you say about
through,
paragraph 10 and the definition of strip search?
Sorry, the definition of strip search is in paragraph 9, my lady.
Right, okay.
That it's absolutely clear, which is why Lord Justice Pitchford says that it applies to all strip searches. So A would apply.
Rather depends what you mean by strip search.
It does.
Doesn't it? I mean,
Well, yes, but what we mean by strip search is set out at paragraph 9.
A search, not seizure, not removal, but a search.
Well, I guess it's not an ideal situation insofar as that is the difficulty with Section 54. If Section 54 is permissive of the forcible removal of clothing, PD says, then we have to have the protections of Annex A, Part B. There's no suggestion that that decision is wrong, and the respondent doesn't take that point. Obviously, it's a matter for you, but we say that must be right because that is in conformity with Human Rights Act protections. You can't just strip somebody naked without there being some protection, and that protection is not set out in section 54 itself. And therefore we have to look to the code, and the code tells us if you take off somebody's clothing, which is more than just their jackets and shoelaces, then that is a strip search. And there's no suggestion, for example, that PD was wrongly decided. For example, if you look at...
I mean, just going back to PD and the points I put to you earlier, paragraph 35 of PD, page 113, does confirm, as I said, that PD was a strip search case.
Yes.
Because it was a subsection 6A case. Whereas ours is a section 54(4) case, going back to my lady's point. A seizure case, rather than a search case.
The facts are, there's no difference in the facts, my lady, that's not right. She's a young woman, comes into custody, she's standing in front of the custody sergeant. If you look at the facts, that's exactly, it's an almost identical set of circumstances, other than the fact that she has a history of self-harm, which is was readily ascertained from the police national computer. So there was no difference in powers used. And he talks of 54.4, 54.3, 6 and 6A. It wasn't pinned onto 6 as opposed to 6A. Indeed, I don't think the respondent has suggested that this is either a 6 or a 6A case, but certainly on the fact of PD, she had just been brought into custody in exactly the same way as Mr. Carter.
Is there, I've missed it, I think, where do we see in PD what the authorisation was for, what the custody officer authorised and why in that case? I'm sorry to...
It's not in the judgment.
...trouble you, but I'm struggling a bit with that.
Paragraph 14 of the judgment.
Thank you.
The final sentence.
Yes.
14.
Last sentence of paragraph 14.
So he found, or she found, it was not a search, and at paragraph 18, held that since the female officers had not been engaged in a strip search, the relevant part of Code C did not apply. And did the Court of Appeal address that?
Yes, the Court of Appeal did apply. That was the whole purpose of...
Yes, but did it deal with what the sort of what this was? What is a strip search?
Yes. So,
paragraph 30, perhaps.
It starts at 29. And at 33, he says it would make little sense for paragraph 4 to apply to clothing retained as a result of search for some other thing, but not clothing removed because it was itself liable to seizure and subject to 4. Then at 34, he says, whilst the word search may not describe exactly what P.S. Gilmore ordered in the claimant's case, in my opinion, it was a search for the purpose of section 54 and Code C, paragraph 4. 4.1 states that when custody officer considers necessary that more than outer clothing should be removed, Annex A applies, and then he goes on to say Annex A provides that a strip search should take place, etc. So he treats it as a strip search within the meaning of paragraph 9 of Annex A. And respondent's argument in that case was that it wasn't, Annex A doesn't apply because it wasn't a strip search, and Lord Justice Pitchford said, yes, it does, and it is. And that is the essence of the decision there.
But it is clear from paragraph 35 that paragraph 10 did not apply.
Sorry?
It is clear from paragraph 35 that paragraph 10 did not apply. Look at the penultimate sentence. Since it's my view that she was searched within the meaning of section 54(6)(a), and by Code C paragraph 4.1 and paragraph 9 of Annex A she was strip searched, the search was to be conducted so far as the context allowed in accordance with paragraph 11. Not 10, 11.
Yes, I understand, my lady, but paragraph 10 was not relevant because in this case, there was no argument heard about its applicability because the challenge was not being made to the exercise of discretion of the custody sergeant. So all he is saying there is that it fails to provide for those situations anticipated by section 54. He doesn't say that that belief is inapposite or inapplicable. Milady, in that case, there was no challenge brought in the court below to the exercise of the custody sergeant's discretion. And I can say that by the time it came to the Court of Appeal, it wasn't open to me to argue that point. So that is not what Lord Justice Pitchford is looking at, and he doesn't look at it at any point. He, as I've already said to you, he proceeds on the basis that the decision made was based on reasonableness, as I've already taken you to paragraph 5 of that judgment. So I'm afraid, my lady, I don't agree that that is what he is saying. Can I deal, if I need to, with a point that the respondents, well, I'm assuming I need to, because the respondent makes a point relying on the case of CXF to say that the 1995 version of Annex A, Code C, and we know from Professor Zander that paragraphs 9 to 12 of Annex A came into force first in 1995. The respondent says you can't rely on Annex A Code C as an interpretive tool because it postdates the enactment of the sections themselves. And to make good that submission, they rely on CXF. And I want to deal with that because that case is entirely distinguishable for at least two reasons. If we look at CXF, please, it's at page 136 onwards. And in particular paragraph page 142, it sets out that it's a complaint about the fact that statutory interpretation isn't properly dealt with, but goes on to say that at 21, the relevant context of such provision is both internal and external. Nothing controversial there, but then at 22, a particular question arises on this appeal is whether in interpreting the Act it is relevant and legitimate to have regard to the contents of a code of practice prepared by the Secretary of State and issued under 118. And section 118 requires this code and any alteration to be laid before Parliament before it takes effect and to be withdrawn, etc. That code is a due regard code, and section 118 simply says that in performing functions under this Act, persons mentioned in subsection etc. shall have regard to this code. And it's not in the bundle, but I can produce it for you should you need it. But it is simply a due regard code. And if you contrast that, then please, with PACE section 67, which you will find at page 38 of the authorities bundle. There is a world of difference between the codes to PACE and a due regard provision. I've already taken you to section 38 or 30, is it?
9.
39. Section 39, sorry, which requires custody sergeant to act in conformity. But if you look at 67(11), top of page 38, and it will be a section that you will be familiar with, that in all criminal and civil proceedings, any code shall be admissible in evidence, and if any provision of a code appears to the court or tribunal conducting proceedings to be relevant to any question arising in proceedings, it shall be taken into account in determining that question. That, we say, indicates, combined with 39, the very special status that the codes of practice have as far as PACE is concerned. In any event, we don't really rely on Annex A of Code C as an aid to interpretation, but rather that the requirement for the belief to be reasonable is provided in that annex. And given that the power to strip search is not readily apparent, it's clear that Parliament intended to or has set out the limits to a strip search in Annex A, and in any event, as I've already said, section 39 of PACE makes plain that Code C is not guidance in the sense of section 118.
And Mr. Gann, we've interrupted you a lot, or certainly I have. We're conscious of the clock. You will obviously be finishing by 1 o'clock.
Yes, so I'll speed up.
Well, is that it on ground one? What more would you like to say?
Just to draw your attention, if I may, that the common law position as set out in Linley and Rutter, and you'll find that at page 45, it was said that a standing instruction to remove a piece of clothing, in that case a woman's bra, was insufficient, and there is a reference in that case to the common law rights of personal freedom, privacy and dignity, and it says forcible removal requires considerable justification. That was the common law position, and we don't accept that the language of section 54 as drafted can override basic common law rights. Yes, PACE codified the position, but it doesn't mean that it then turned away from the fundamental rights. And my lady will know what is said in ex parte sims, etc. And so I I won't turn to it. The last point I want to make about this, that if Lord Justice Pitchford is right, and we say he is, that section 54.3 and 54.4a and 6a together describe a strip search, then that lower threshold of subjective belief would be in conflict with convention rights, and if necessary, it is perfectly possible to read that in by way of section 3. It will still give effect to the intention of Parliament to seize clothing which may protect the detainee, but will do so in a more just, less arbitrary and more proportionate manner. The court has done that in various cases. So a compatible construction is entirely possible, we say. Moving then on to ground 2, my lady, whether Mr. Justice Spencer was right to interfere with the conclusion of the learned recorder that Police Sergeant Bailey did not hold reasonable belief. We recognise that to a degree this ground depends on this court finding that the recorder applied the correct test. Mr. Justice Spencer made this assessment as an alternative, as you all know, that even if the test was reasonable belief, the recorder was wrong to find that Sergeant Bailey's decision was not reasonable. There remains, even if my ladies, my lord are against me on what the proper test is, it seems to me that a point still remains, that slightly separate point, that if this court finds that the recorder should have approached the custody sergeant's powers as on an honest belief basis, as opposed to a reasonable one, it's not at all clear that he found even that state of mind was made out.
But that's not in your appellant's notice, as I understand it. I mean, is it?
But it may flow, is what I'm saying.
Well, what is your positive submission then?
Well, if you were to say, oh, well, it's the wrong test, so it doesn't really matter, the difficulty that arises is that he hasn't, looking at the judgment, even found that honest belief is made out.
Well, he does at para 182, doesn't he? As I have found. Isn't that what the recorder said?
He finds that
there was an actual belief. Let's look at it.
Let's look at it then. Sorry.
No, don't worry. Maybe I'm wrong. I agree that it's very difficult in this long judgment to find clearly some of the necessary findings. But if you get to 182, I have held that Police Sergeant Bailey and the police officer's primary actual motivation was the belief they were required to remove the clothing where the detainee had not answered risk assessment questions, simply because that itself would suggest a risk of self-harm.
Yes, but he goes on to find that to be irrational, and also that it is...
But they held that was their primary actual motivation. So, I mean, anyway, is there a ground of appeal which says, and in any event, the recorder didn't find actual belief?
There isn't. It's one of those points that occurs to one.
Well, I've spent a long time trying to find other bits where one can pin para 182 down, but that's what paragraph 182 says. Is that the closest we get to it?
Yes, but I say if you look at it as a whole, in fact, he doesn't make a finding, because it must be right that an honest belief can't be rational, whatever else it may be. And he appears to find that the belief, whatever it is irrational.
You can have an irrational actual belief.
Well, but that wouldn't be sufficient, we say, for the purposes of this Act. But coming back to this ground, it's set out in our skeleton. The recorder carefully weighed up all the evidence, and the extent to which weight was given to any fact was a matter for him, and his reasoning can be found at paragraph 182 onwards. He sets out 183, for example, that the fear of head banging that Sergeant Bailey spoke about in her evidence as a justification, that wouldn't be reduced by stripping somebody naked. At 186, he's right that there's no compulsion to answer risk assessment questions. It's irrelevant in a sense as to where that right stems from. It doesn't matter that there isn't a right to silence. It's simply, you've seen the questions. It's not uncommon for detainees to refuse to answer questions. All he was saying is that refusal cannot amount to an establishment of risk. And that, we say, cannot be characterised as some kind of misdirection, as the respondent suggests.
The first sentence of paragraph 182 does talk about the sergeant coming to the conclusion simply because that itself would suggest a risk of harm, but then goes on to say, although this was also combined with a fear that the claimant had threatened to attack officers already. What does that mean, do you think?
Sorry, what does what mean?
That sentence taken as a whole. The first bit says it was only because he wouldn't answer risk assessment questions, and the second bit says it was because he was violent. How can that make sense?
Primary action motivation was belief that they were required to know where the detainee had not answered questions simply because the officer's risk of self-harm, although this was... Sorry, I'm being stupid.
No, I don't think you are. Don't worry. And
Sorry, what is
please
your
don't
question?
apologise. I'm just asking for any help you can give in actually understanding that sentence, because the first
Which sentence, my
the
lord?
first sentence in paragraph 182, the first part of it seems to be inconsistent with the last bit of it. That's my problem. Maybe I'm
Yes,
misreading it.
he's simply saying, I'm sorry, it's not actually that difficult in the sense that he's saying you need something more than a simple failure to answer risk assessment
Yes,
questions.
such as the fact that he was being violent.
Well, but he's made a specific finding that he wasn't violent. That was the perception of the police officers. And you've seen it on the footage, that he raises his arm, and
Yes.
that is it. That is his specific finding.
Yes, so the police genuinely believed that he was being violent. Was that the finding?
That was the finding.
Yeah.
But it's caveated to, I can take you to those. I try to open by setting that out.
Yeah.
To say that that there was a quick movement of an arm, and that was perception by police officers, but a custody sergeant watching that from her angle, that doesn't mean that she forms the view that he's violent. That is what they did in response to a flick of an arm, which you've seen yourself.
Yes, we have.
And he makes very specific findings about that. And that is why I also talk
Yep.
about the bite.
Okay. Thank you.
To characterise him as violent is to miss the nuance of what happened to this appellant in that custody suite, my lord. And whilst I obviously hear that you consider that the reasoning in this judgment could have been tighter, certainly it is nuanced and it is careful, and it is as a result of a recorder who has sat there and listened carefully to all of the evidence, watched footage, listened to the appellant's evidence. And at 190, you can see that he goes on to deal with why the perceived threat of violence and the degree of intoxication was not enough to infer self-harm. And I hope that that helps my Lord answer the question my Lord posed in relation to 182. He goes on to say that the suggestion that the blood on his face, there was no suggestion related to self-harm, and that was obvious from the moment he came in. There was nothing to suggest that the clothing would be used to attack anybody. And at 192, he says there's no reasonable basis, and also that the finding was irrational. And at 193, even if rational, not reasonable or proportionate. And if we look then, and which I'm sure you have, and I am mindful of the time, but I'm sure you've looked at paragraph 49 of Mr. Justice Spencer's judgment, where he uses words like, I have considerable misgivings, and indicates that the recorder did significant disservice to the evidence. Police Sergeant Bailey, and you can see that at paragraph 49, which is at page 68. We say that there, Mr. Justice Spencer did exactly what the authorities suggest a second instant court should not do. He carried out the balancing task afresh instead of identifying flaws in the reasoning of the recorder. And we've set out at paragraphs 52 to 60 of our skeleton the recorder's careful analysis where it can be found, and that there's no flaw of the type required before interfering with an evaluative decision such as this. My ladies, my lord, you will, of course, be familiar with the case law in this area, and we're relying on Sprint Room. I won't take you to it because you know well the circumstances in which a court should interfere with a first instance reasoning. But if you want to, I can take you to it. If you need reminding, you don't. The Sprint Room, just for your note, starts at page 151, and we rely in particular on paragraphs 75 to 78. There is also reliance on the Greater Manchester case, which was also cited in Afriye, and so we rely on paragraphs 76, 77, and 78. And in that case, there's a sort of well-known quote about a whole sea of evidence versus island hopping, and we say that is what Mr. Justice Spencer did. Moving on then to ground 3, paragraph 53 of Mr. Justice Spencer's decision is at page 70. Again, we say this is a retaking of a decision without the benefit of the trial process. The recorder's findings in the liability judgment at page 169 deal with all the points made by the respondent, all of them, and he rejects them, as he was perfectly entitled to do. Additionally, at 194, he makes the point that the appellant was never warned. At 195, he sets out why he considers Mr. Carter would have calmed down. He's perfectly entitled to make that finding. At 196 to 197, he bears in mind the College of Policing guidance as well as Annex A. And importantly, at 198, he says the risks could not justify the conduct of the police officer. We say if you look at Mr. Justice Spencer's reasoning, it completely ignores the nuance and reality of the recorder's finding. It it just talks about the appellant having been drinking and being violent, but I've already set out the recorder's very nuanced findings about the fact that he was responding to the situation as he perceived it to be, and as were the officers. But he talks about a refusal to answer questions, but and it's right, he doesn't answer questions, but that, we say, could never be enough. And it's important that the recorder found that he was mildly drunk. Again, he makes reference to the biting, and we say that's misleading because the recorder found that the appellant was acting in reasonable self-defence. The respondent suggests in his skeleton argument that the High Court judge was in the same position as the judge as far as use of force is concerned. We say that is simply wrong. The recorder heard the evidence of the claimant and the officers and assessed the credibility. The footage at the desk when the appellant is taken to the ground is without audio, and the recorder heard the competing accounts himself, and he was entitled to form a view about what the claimant would or would not have done, having heard all of the evidence.
What was there in the competing accounts about the audio that went above what we see on the video?
Well, there is no. Oh, sorry. Was there competing accounts as to
yes,
what transpired?
what was there from the oral evidence that the recorder heard that would be relevant to ground 3 that we don't see from the video? Always delighted to hear from junior counsel if the opportunity arises, Ms. Sikand.
Oh, he was in the court below. I wasn't. Sorry.
No. Genuinely, if Mr. Wand wants to explain what the oral evidence was, we'd be delighted to hear from him. It was a genuine offer.
You want to? He's declining your kind invitation. In a sense, it's unfair to make junior counsel address such an august bench without some preparation.
Right.
But to say that there was competing accounts as to what the police officer was trying to say and what Mr. Carter was trying to explain, he was protesting his innocence, and you may know that he was recently bereaved and the funeral was the following day, and so his focus was on trying to get that across the custody sergeant. But I'm not sure that in a sense was in conflict, but it was the recorder hearing what the custody sergeant said she was doing and what Mr. Carter put across to him as to why he was not able to answer or not answering questions. So it's in that context, and you'll recall that earlier I said he considered it disproportionate to simply take someone to the ground in the circumstances that they did. Having heard from him as to what he was doing and why he was doing it, having heard from the custody sergeant as to what she thought was going on, and she was pressed about this at some length, he was entitled to take a view about what the claimant would or would not have done. The respondent makes a suggestion that the recorder was applying the wrong test of absolutely essential as opposed to reasonably necessary in their skeleton at 64. There's absolutely nothing in the judgment to suggest that that's the test he applied when considering the reasonableness of the force, and we say there's nothing that justifies Mr. Justice Spencer's decision to simply replace his own thinking with that of the recorders. Moving on then to ground 4, and I can take this quite shortly. My lady may even be pleased that I'll finish before 1 o'clock. That this ground, as my lady knows, was not analysed by Mr. Justice Spencer, preferring to leave it to you. He anticipating that may happen. The breakdown of the award can be found in the order at page 128 of the core bundle, and it's just more useful to see it there, I think, than try to extrapolate it from the liability judgment. I think I've got the right page. Yes. So you can see there at the top of that page, 10,000 for injury to feelings, 7,125 for psychiatric injury, 5,000 for AGS, and 910 for the special damage, which was the damage to the coat that you know was cut off. The respondent takes no issue with the 5,000 or the special damages. Of course, that would be difficult to challenge. But we say that the respondent's position is somewhat opaque when it comes to the question of injury to feelings, even if the recorder was wrong about the materiality of the adjustment disorder. At paragraph 1 of his quantum judgment, which I know my lady has indicated you have already read, but I'll just flag the paragraphs which are of importance. He distinguishes between what he described as damages for non-clinical consequences and injury to feelings. So he makes a difference between, damages for non-clinical consequences, which are, in other words, injury to feelings and anxiety and distress of a nature which is below that of a level being recognised by a medical condition. So you can see that he has that well in mind, that whatever Dr. McGillian says, that there is a separate element for injury to feelings, and although he recognises that they can be to an extent related, and as my ladies, my lord knows, injury to feelings are about the indignity and the mental suffering, the humiliation, the distress that might be caused, and as well as the anger or indignation arising from the circumstances of an assault. And they are separate from aggravated damages. They are traditionally part of general damages. And here the recorder repeatedly found the whole event, as you know, and I have said that a few times, to be degrading and humiliating. He says it in the liability judgment, and he says it in the quantum judgment, and at page 179, he says, when referring to watching the footage, he says he reminds himself of it. That is a clearly degrading, humiliating, frightening, and traumatic for the claimant. Both kinds of damages, that is to say, psychiatric damages or psychological damages, as well as injury to feeling, are available in assault cases. And at paragraph 20 of the quantum judgment, the parties agree that injury to feelings is a recoverable head of damage, and it is well established, my ladies and my lord, that there is no rule against making separate wards in respect of both psychiatric injury and injury to feelings, as long as the court is conscious to avoid overcompensation and double counting. So, of note, at paragraph 64, the recorder makes plain that the £5,000 aggravated damages would have been higher but for the injury to feelings award. So if you look at that, paragraph 64, he awards a 5,000 but says, but for the injury to feelings award, it would have been higher. As you know, the difficulty that arose for the recorder was the way in which the psychologist expressed the adjustment disorder and its causes. At page 54 of the supplementary bundle, she says, it was all of phases 2 to 4, in addition to the court case that followed and witnessing the CCTV footage that led to the development of Mr. Carter's adjustment disorder. And that if phase 3, and here she means what I have called the strip search, had not occurred, but he had encountered these other experiences, on balance, he still would have developed traumatic stress symptoms, albeit these may have been somewhat milder. On balance, however, there probably would not have been a significant difference in terms of presentation severity or prognosis. I accept that the but-for principle is the primary mechanism for determining factual causation in the law of tort. But that opinion by the psychologist made a traditional but-for analysis challenging, hence the recorder's focus on material contribution. And my lady will know.
As a matter of principle, that was the right approach.
Yes. In these circumstances, it was the right approach. It seems here that the expert is saying that the strip search may have made the injury more serious, but not much more serious. And the recorder found his way around by trying to work out a figure to reflect that worsening. And you can see that at paragraph 50. So we've set out why we say he wasn't wrong to do that in our skeleton, and I'm not going to go over that now, but we say that even if the figure he came to for psychiatric injury was too great, there is no basis for extinguishing the award entirely, but there certainly is no basis for extinguishing the award for injury to feelings, which it appears to be what is suggested by the respondent in this case, that he should only be entitled to £50. We don't...
Can you remind me of that? That's the suggestion, is it?
That's a suggestion, but from Mr. Stagg, that it should be a nominal amount because of the difficulty with causation. That is to say, if there's more than one, that if the injury would have been caused in any event by the non-tortious events, then the appellant's not entitled to anything other than some nominal damages. But we say he entirely sidesteps injury to feelings, and we don't accept that such a derisory amount would have been appropriate in the circumstances. So those are my submissions. And I'll let Mr. Stagg start on this. I can assist any further at this point.
I think Mr. Wand may
Oh,
just have
Mr.
something for
Wand.
you.
This is in answer to the point that you'd invited Mr. Wand to get on his feet about what the sort of conflict at the custody desk. He says, please, could we look at paragraph 22, which is at page 133. I don't invite you to turn to it now, but to make a note, please. Paragraph 133, which is at page 157.
Sorry, I've got page 157.
My lady was page 157, paragraph 133, and page 133, paragraph 22.
This is phase. This is still phase 1, is it not? Not phase.
Yes, but it feeds into it's a phase. This is about the use of force, so that force happens at the custody desk and then continues. So,
Okay.
if you recall from the footage, and you may not, I having viewed it just a few more times than you have. He's at the desk. There is the movement of the arm, and then they take him down, and then immediately.
But that's still all phase 1. You say that's relevant to the assessment of phase 2, do you?
Well, it's relevant to ground 3, which is about the use of force.
But the judge makes it very clear, doesn't he, in his quantum judgment, that what he's found to be unlawful is what happens in cell 28.
28.
Yes, in cell 28.
Yes.
So we're not looking at the force in phase 1, are we?
But it follows. It's the force. Yes. So the force. You're right. The force used to take him down, as it were, is distinct from the force that is then used.
We're looking
to
at
strip off
force in
his-
cell 28, is my understanding,
Yes.
on ground 3. Is that right?
Yes, it is 28, not
Yes.
26.
So not,
Yes,
not
so
at the custody desk.
Yes.
Not at the custody
Yes,
desk.
the
So
force. So
Yeah.
the force used to carry him into that cell, to strip off his clothing, to cut it up, and
That's the force we're looking at.
yes, that's the force.
And thank you to Mr. Wand, but so the paragraph that's relevant on that is, and we've got the two references we've just been given relate to the custody desk.
Yes. Yes, that was a response to the conflicting dialogue at the custody desk that Mr. Wand was
Right,
responding to an earlier question.
Okay,
which
but
was
so
in
far as
response to the submission that I was making.
But is there any relevant conflict, do you say, from the oral evidence in relation to phase 2 that you wish to draw to our attention? Something that's not on the video that is material to the assessment of force?
No, other than you will see that there is a dispute about what the appellant was saying, and what the officers were saying, and that that is detailed though as to who was swearing at which point,
Okay.
when. And there was a dispute about what.
And we've got that at 165, I think. And there's the findings.
Yes.
Oh, well, that's still based on the video. That's still based on the audio. I don't see anything from the judgment at first instance.
In terms of the necessity.
Of oral evidence that was relevant to the question of force. You have a think, and Mr. Bond may be able to just help us on that.
So
But
I'll come back.
That's my focus.
I'll come back,
Thank
if
you.
I may, on that point.
Before handing
please.
over to my lady and my lord, just Miss Second, can I just thank you very much indeed for your patience in answering so many questions this morning and assisting us on your feet as you have done as well on paper. It's very much appreciated.
It's my pleasure. I'd like to, not exactly my pleasure, but it is my job, my lady. Thank you.
Yeah.
No. And Mr. Warren, this is another invitation. Do you follow? Is there anything you'd like to add? No. No. Right. Thank you very much indeed. Yes, Mr. Stagg.
Your Ladyships, my Lord, I start with a summary of what we say in relation to the various grounds. Under ground 1, the relevant provision, subsection 4A of section 54 of PACE, means what it says. The custody officer must have an actual belief that clothes or personal effects may, and I emphasise the word may, be used by the detainee for one or more of the listed purposes. But it's not necessary for there to be a reasonable basis for that belief before the power to seize clothes or personal effects can be exercised. And we say there is no basis to read in such a requirement, whether under Section 3 of the Human Rights Act or otherwise. The Recorder therefore erred in law in proceeding on the basis that the belief of the custody officer, Sergeant Bailey, needed to have a reasonable basis before she could exercise that power and require the claimant's clothing to be removed. On ground 2, firstly, if you're with us on ground 1, the ground falls away because the reasonableness of Sergeant Bailey's belief is legally irrelevant. In any case, I shall seek to demonstrate that the Recorder's approach to whether there are reasonable grounds to believe was seriously flawed, and that Mr. Justice Martin Spencer was entitled to reach the conclusion that Sergeant Bailey did have reasonable grounds to believe that the claimant may, and again I emphasise that word, use the clothes to self-harm or possibly to maintain an attack on officers. Under ground 3 again, we say the Recorder's approach as to whether force was necessary was seriously flawed. And again, the learned judge was entitled to overturn his decision on that point. And ground 4, I'm going to ask Mr. Messling to address you on that point. I have forewarned him.
Thank you.
Can I address you before the lunch interval on the proper approach of the court to this appeal? Ground 1, of course, is a simple question of law, and so there's no difficulty there. Grounds 2 and 3 are a challenge to, firstly, Mr. Justice Martin Spencer's finding that the Recorder's evaluative decisions on the reasonableness of belief and necessity of belief were flawed, and secondly, to the substituted decision that he made. You've been referred by my learned friend to the case of Sprintrum, and you'll be familiar with the taxonomy there. It's in the White Book. I don't take the court to it. But taking account of, or failing to take account of material factors, the converse must also apply if you take into account irrelevant factors in the exercise of your evaluation. That also is a relevant error, which will entitle the appeal court to intervene. In relation to the recent decision in Afriyi, and the court may be aware that the Supreme Court has now, within the last week, refused permission to appeal in that case. So the Court of Appeal's judgment stands in that case. In relation to a fee, the court made the point at paragraph 38 of its judgment that because the evidence turned largely on what could be seen on, in that case, body-worn camera, in this case, CCTV in the station, that the appellate court was in an unusually good position. That, of course, was the case for Mr. Justice Martin Spencer. And I do say that one has to bear in mind that this trial took place a very long time after the events in question. They were fast-moving events, they were confusing events, there was a lot of shouting, a lot of noise, and therefore one might take the view, and I do invite the court to take the view, that the most useful evidence was what one could see and hear on the CCTV footage. Finally, on this point, this is, of course, a second appeal, and I was not able to locate any authority on how you approach the issue of evaluative decisions when a first instance decision is overturned on a first appeal. In my submission, the right approach is this. You must decide first whether Mr. Justice Martin Spencer's decision that the Recorder's approach was flawed was correct. If you disagree with him, then it follows that he was not entitled to interfere with that evaluative judgment. If, however, you agree with his decision that the Recorder's approach was seriously flawed, then you may you may only overturn his evaluative decisions on re-sprint room grounds. I say that because, like him, you are under Rule 52.21(1) limited to a review of the decision of the lower court, and therefore, unless you felt able to interfere with his decision on similar grounds, his decision would have to stand. My lady, that I think takes us through to nearly 1 o'clock. I'm about to move on to look at the various aspects of the legislation. Would that be a convenient time?
Yes. I think on ground one, your primary case, you have set out very clearly in writing. So
yes.
I don't think we need to go through all the PACE provisions, speaking for myself. I think what would probably help us most, and you can perhaps think over the short adjournment if that needs any rejigging on your part, is to address the arguments that we've heard this morning from Ms. Sick, and rather than setting out your primary case, and we're not in any way suggesting you don't dwell on your primary case, but if there's anything you think we might have missed, your position is the words mean what they say. You draw attention to all the other sections in the Act where reasonable grounds to believe is used per contra, but by contrast. And then you need to deal, as it were, in rebuttal with the Annex A point, the Articles 3 and 8 points, and other bits about pre-enactment aids and all the rest of it.
Yes, I think I can certainly cut a good deal of the material that I had prepared.
Just on the primary case, and we know you draw attention to the sections where the Act uses different language.
Yes.
You say deliberately, you may be right or wrong, but that's your submission. And and then it's really dealing with Annex A, the code, and Articles 3 and 8, isn't it? Along
Indeed.
with the pre-enactment materials. I think that would help us most if you started, as it were, a little way into the debate.
I'm very grateful for that indication. I'll endeavour to follow that course.
Do you agree with that? Are you happy with that? Yes. All right. 2 o'clock. Thank you very much indeed.
Can I pinch that other lectern, actually?
Oh, yeah, it's not doing anything. Oh, you need two?
Yeah, just so I can balance the...